All right, well, thanks for coming. The reason for me asking you to come today is yesterday afternoon I was informed by my law director and Mr. Singletary that we had a problem associated with some, basically some traffic ordinances. And that problem was that we on a routine basis update our traffic ordinance to comply with state law. So it's something that we do routinely. And my understanding just from talking to my lawyers before I came in, that in the old way of doing things, it used to be done all in one piece. And now, for whatever reason, the state has separated them into two things. So you have the violation itself, and then you have the penalty. So those become two separate things. So what happened was that there was a passage of legislation to update and to get in line with state law on the ordinances, the violation themselves, but there was a delay and there was not a passage of the legislation that we needed to pass to incorporate the penalty to it. So I'm trying to, if it's clear. So as time went on and people were cited for and we'll give you what these citations are, right? As people were cited for these things, it did not mean that they did not violate that particular traffic or law. What the problem became is that in the sentencing phase, that if you do not have a traffic law that has a penalty associated with it, then it automatically converts to a minor misdemeanor. So let's take, for instance, driving under suspension. Your license is suspended. That's a misdemeanor 1, which is up to a $1,000 fine, 180 days in jail. That's the maximum. A minor misdemeanor is, I don't think that, $150 fine, no requirement of days in jail. So what happens is if you're arrested for driving under suspension, your license suspended, it did not mean that they were wrong on the convicting you for driving under suspension, because you were. The question became, what was the appropriate penalty? And since the second ordinance did not get passed, there was a period of time where there were people who were either pled guilty or convicted of these violations, and they were sentenced as if they were misdemeanor 1s or 2s or 3s, when in fact, because the other ordinance had not been passed, they should have been viewed as a minor misdemeanor. So it's really about the penalty in the sentencing phase associated. So that's what we want to alert you to, talk to you about today. And Barbara Lang-Henry will give you, the law director will give you a little bit more than what I've said, and then Judge Patton, representing Judge Adrian, administrative judge, will talk to you about some remedies as we move forward. Okay?
Good afternoon. As the mayor said, on a routine basis, we look at our traffic code and try to comply it with the state code. There are certain circumstances where we may differ, and so that's also part of the analysis we do, is determining those areas. So this is a routine thing. In May, amendments to Chapter 40, May of 2016, amendments, the council passed amendments to Chapter 403. And I have a copy of the affected section. That section, Chapter 403, included a penalty section. Before May, before it passed, our penalty section included penalties for violations that are in Chapter 435. When it was amended to conform with the state code, those provisions setting the penalties for items in 435 were dropped out of the code. There's a companion piece to amend Chapter 435 to place those penalties into that chapter. So it was part of trying to make the code regular and understandable. It's a little odd that penalties for sections in one chapter are contained in another chapter. The two pieces had been separated, so the changes to Chapter 403 passed in May. That meant that the penalty sections were dropped and they weren't placed into another section. As the mayor said, if there is no specific penalty for something, then it is a minor misdemeanor. And so beginning in May, when we believe judges were sentencing people to a higher sentence than the violation warranted, because the code was saying that it's a minor misdemeanor. This all came to our attention because a defense lawyer was working with one of our prosecutors, and in the context of that, they were talking about a plea and possible sentencing, and she pointed this out, and this was late last week. So this came to our attention, and we assessed it and came up with a plan. As of Tuesday morning, we instructed all of our prosecutors to immediately notify the judges that in any of these cases, they were to be sentenced as minor misdemeanors. In addition to that, the police will start citing under the state code until we can get our code in line. And we are working with the court to identify each of the cases where someone may have been sentenced to a higher penalty than was directed under the code, and we'll work with the court on those things. And the judge will talk about what the court is going to be doing.
Thank you. Good afternoon. You're all going to receive a copy of the administrative order that was filed today, taking corrective action. And corrective action, we've identified 5 people who were sentenced to jail after being found guilty of an offense. But the penalty section was missing from the ordinance. And as soon as we discovered this last week in my courtroom, the prosecutor's office was notified. They are looking into the matter, working with the clerk's office to identify everybody who was put in jeopardy by this and taking corrective actions. As the mayor said, this was a routine procedure to bring the city code into compliance with the state code. It's a difficult concept to understand that there's a state law and a city law for driving under the influence or driving under suspension. The penalty should be the same. So they were correcting that, and we just discovered the omission this week. So we're correcting it now. And I will read to you the first paragraph of the administrative order. On May 16th, and you'll receive a copy of this, on May 16th, 2016, effective May 18th, 2016, the penalties provided for a number of first-degree traffic ordinances found in the city's codified ordinances were converted to minor misdemeanors. Therefore, convictions that were obtained under these sanctions were valid. That's important. They were valid convictions, just the wrong penalty applied. But many of these sentences exceeded the maximum for a minor misdemeanor. Sentencing adjustments will be made as needed and determined. Sections of the codified ordinance were converted from first-degree misdemeanors to minor misdemeanors. And there's a list taking up the whole page of the ordinance that were affected. Now, the court being fully informed of this premise offers that the orders that all of the following steps be taken to remediate any judicial actions that are or were inconsistent with the legislation passed by City Council relating to these matters May 16th, 2016, and effective on May 18th. There's another page of remedial corrections we're taking. As of this moment, we do not know how many people were affected, possibly. The clerk's office is researching. As I said, we discovered a total of 5 people who were sitting in the workhouse convicted of something that was a misdemeanor of the first degree, but should have been sentenced under minor misdemeanor proceedings. They have been released as of today. There may have been some other people jailed for something we don't know. They may have had additional charges that weren't affected under this section, but were sentenced. So that it's complicated. It's like a Chinese puzzle, and we're going to try and figure it out and fix it, and try and make sure it doesn't happen again. So with that said, Mr. Mayor, thank you for the time.
Why would
penalties changed to begin with? Was it associated with the RNC town?
No, the, the penalties were not changed. The mistake is that the second ordinance that contained the penalties were not passed. And when you don't have that ordinance passed that contained the penalties, then it reverts to a minor misdemeanor. So the penalties were not changed. As the judge said, the people were convicted or pled to these charges. It did not mean that they didn't commit whatever it was. The issue became, since the second ordinance that incorporated the penalties had not been passed, then it was automatically supposed to be a minor misdemeanor rather than a misdemeanor 1 or misdemeanor 2.
So what was the purpose of the legislation being passed? You mentioned like for driving under suspension, that was a misdemeanor 1, penalty of $1,000,
Right.
180 days in jail, but because of this, it's a minor misdemeanor, $150. Why was that changed, that case?
Well, it was, see, what I'm trying to say to you, it was not changed. The mistake was that there was not a passage of the second ordinance. Under the old way, when they passed one ordinance, everything was included, the offense and the penalties, they was all under one. When they separated it, it meant you had to pass 2 ordinances.
Will the second ordinance
It did.
be passed? I mean, is it?
Well, it'll be
It will be.
be considered by council, yes.
Right, that's right.
What happened is we were moving the
Come on,
penalties.
come on.
We were moving the penalties from chapter 403 into chapter 435. But the ordinance affecting 403 passed, and the ordinance affecting chapter 435 did not.
Right. And that's why when you have that situation and you have an offense that does not specify what the penalties are, it will convert to a minor misdemeanor. Now, under the old ordinances and under even the new one, if the second one would have passed, there would be no issue because whatever the sentencing was would have been appropriate. But because they didn't pass the penalty section, you can only sentence them based on a minor misdemeanor. And anything above that is a problem.
So basically, you would like for the legislation to go back and have it go back to the original sentence?
Well, no, what I'm saying is, in effect, this is routine. And what should have been routine turned out not to happen. And as a result of it not happening, we had the separation of somebody committing an offense and what the penalty should be for them committing that offense. And when you don't have the penalty pass associated with that, it's automatic a minor misdemeanor. It's just automatically. The mistake was that we failed, meaning us, failed to send to council the second piece of legislation that should have been passed that would have said this is a misdemeanor 1, like it's always been, subject to a $1,000 fine, 180 days in jail. Then whatever sentencing, and the judges, what they did, since they know that this particular offense normally is a misdemeanor 1, a $1,000 fine, 180 days in jail, they just operated like that. They just operated like that routinely. It's what they do routinely. But now, since they found out that the second ordinance had not passed, and by law, it means that what used to be a first-degree misdemeanor is now a minor misdemeanor, they have to go back and correct all the sentencings that they did. And that's what Judge Adrian has ordered to happen. And that is what the clerk and administrative side of the court system is looking at, identifying those who have been affected by this. Now, let me point out a couple of other things so you know. Someone may have had one of these things identified in here that should have been charged as a minor misdemeanor because of the failure to pass the second ordinance, but they may have been arrested based on the fact that they had another offense that was arrestable.
Can I ask who made the mistake?
The law department, we did. You own the success, you own the problem. So the mistake was made that we did not send to council the second ordinance. And we didn't send to the second ordinance, it could not be passed. We only sent one ordinance rather than two, whereas traditionally, all they had to do was one. And the one ordinance included both the offense and the penalty, so there was no issue. In this case, it came down to, I guess, state law now, says they doing two.
And what, do you know what exactly which ordinances, or if it is that 403 section, or like what kinds of driving offenses are we talking?
Well, here, I will give it to you. We'll give it to you. And then,
pass it out.
yeah, we'll give it to you. I'll read like a couple of things here. Placing injurious material or obstruction in the street, right? Stopping for buses discharging children, that kind of stuff. A minimum speed limit, assured clear distance ahead. That's like if you run up and behind somebody and you're given a ticket for following too close. That's what it, those are not minor misdemeanors. Those are some of minor misdemeanors?
No.
No,
they're
those
all
are not
misdemeanors.
minor misdemeanors. Those are higher misdemeanors, which means you can fine up to, you can have a larger fine and you can sentence people to jail.
Correct.
On minor misdemeanors, the most you can do is $150 and no jail time.
No, Jim.
Does that mean that some people who committed these traffic violations are going to get off the hook?
Well, it means that they get off the hook in terms of the penalty side if, in fact, there's no associated other charge that warranted them being arrested, right?
That's correct.
Or receiving them.
Right. But in terms of being the conviction, they'll have the conviction. And I mean, if it's points on your license, it's points on your license. So that doesn't go away. What goes away is whether or not they charge them over what they could charge them as a minor misdemeanor. That becomes the issue.
And just one more question. If someone who has been in jail and you're saying that they can't have jail time now, how do you remedy that?
Well, that becomes what the court, the clerk's office, and our law department figures out to identify each of those individuals and then to identify each individual circumstances. Because like I said, even if somebody may have gone to jail, they may have gone to jail for another offense and maybe wanted, say for instance, you had a DWI, driving while intoxicated. And you also, your license was suspended, so they arrested you for driving under suspension. Well, the fact that the penalty section was left out of suspended license, it has no bearing then because you're going to get arrested. If that makes sense to you.
Why don't you just use the state code?
Well, they have options. When police officers write tickets, that's what they're going to do now.
Right.
So then they won't have this issue.
Then you wouldn't have that issue, you just use.
Well, no, but there
Does
are,
the muni courts get more money?
well, that's part of it. I mean, it's all in the administrative side and what you can find, what you can't find, all that, where the money goes, all this other kind of stuff. But every municipality has its own set of traffic laws, and they have to be in line with state law. Sometimes what you'll find, state law is more stringent than local law, and a police officer will charge under state law just because of the penalties associated with it compared to a municipal law. Is that correct?
That is correct.
And so if it goes before the judge then has a broader range of discretion, or in sometimes mandatory sentencing or finding based on state law, whereas the city law doesn't have it. But all these things are part of why they routinely update. It is routine. We missed a routine, or the law department missed a routine function.
So, Mayor, for somebody who thinks they might have been in this situation and spent time in jail when they shouldn't have, is there like a number they can call to start, getting their money back or working out some kind of resolution?
Well, this has been going on for 10 months, so anybody for 10 months at the law department, you give them a good ear and you will talk to them and you will ferret out their situation to see if in fact their concerns are legitimate. As I said, there are some people who wound up in jail that would have wound up in jail regardless of this.
That's correct.
Regardless of it. So that those people will have a different situation. But if the only reason why you wound up in jail was this, that's another question.
Now, the judge said he couldn't mention numbers, but are we talking hundreds of people, thousands?
They were doing that research now.
This is over a 10-month period. It came to our attention in my courtroom Wednesday, Madam Prosecutor. The assistant prosecutor pointed it out to me. I asked that a brief be written. Then I spoke with the administrative law judge, Judge Adrian. So we have moved on this quickly, but we haven't had time to research how many people are affected since the last 10-month period has been over. And I don't want to confuse you anymore, and I know this is not a simple concept, but the mayor was talking about how it used to be and how it is now. We were on city council together some years ago, and procedurally, the section in the code for penalties was a total section.
Right.
Somehow or another, it got changed in Columbus, and we're trying to catch up with what they do in Columbus. But I didn't know it had happened until I saw it Wednesday, and I was like, why? And then it was explained to me, and I still don't know why Columbus is doing it the way they're doing it, but we have to be in compliance with what happens in the state capitol. So we're getting our code in compliance. We're going to correct the situation for our citizens. This is it's just not an easy thing to wrestle with. So I cannot answer your question today, how many, but we have instructed the computer techs in the court to flag the cases, all of the cases that potentially are affected by this. So as they come up some way on our computer system, we will be notified, we will be correcting the situation. We feel that's our duty to the citizens of the city.
And to follow up on what the judge says, if anybody was done wrong, it needs to be corrected. And whether it was innocent mistake or not is irrelevant here. And what we're doing now is asking you for your help in informing people that if they believe that they've been, this has affected them, then we need to protect their interests. It is not by any malice or any intent to do it. It happened. It just happened. And for whatever reason is irrelevant to me, it happened. And so we're coming to you and telling you what happened. Now, how it was done and who did it, then that becomes another issue that I got to deal with. But here now today, we're saying to the public that during a 10-month period in the city of Cleveland, and we'll give you these lists of violations, and if they were in any way given tickets in regards to it and had to pay a fine, or if they were in any way put in jail as a result of it, let us know so we can correct the matter.
I just want to make sure I understand. So these people, they got penalized by what was on the old code, but those penalties wouldn't change, right?
No, they didn't.
So
You're absolutely right.
Penalties, it's
Right,
just that
that's
it's
right.
technicality.
You got it exactly right. It's exactly right. What the penalties were just the penalties that would have normally been done. It wasn't anything that the judges did or the law department did or anybody did to try to change that. They were penalties that were normally associated with these offenses, but for the fact that the state separated them and we did not pass through city council the penalty side. And when you do that, when you don't incorporate penalty, everything converts on this list to a minor misdemeanor. It just converts to a minor misdemeanor. That does not mean that the offense did not occur. It occurred. It did not mean that they didn't plead guilty to it or no contest to it. They did, or they wouldn't have got sentenced, right? If they wouldn't have got sentenced. If they didn't plead guilty or no contest, they wouldn't have got sentenced. And their expectation was that they were getting the right penalty. And the judge's expectation is that they were delivering the right penalty until we got this smart lawyer who actually read the thing. and figured out that, whoa, wait a minute now, you cannot impose this penalty on them because you did not do this. And as the prosecutor's officers was notified of that, as they were doing a plea bargain, I imagine, and as they were informed of that, they said they're correct. They then informed the director, who informed me yesterday, and I think they informed the judge, when Friday?
Yes.
Yesterday or Friday?
I think I heard first about this from the law director Friday.
Friday. You see?
almost sure.
So it's like that. It's not as if there's been any malice or intent or someone did anything trying to do any harm to somebody. These are normal things. Somebody violated the law, they pled guilty, yes, I did it, or they pled no contest, okay, judge, I'm throwing myself on the mercy of the court. And then they sentenced them according to what they believe was the penalty schedule that has been in place for years.
So when did you send the new corrective legislation to council?
Well, you asked the same question I asked, and if it ain't done quickly, then there'll be other conversations other than the mistake that was
He
made.
went up today.
Right.
Does this mean that there are now many dangerous drivers back on the road?
Oh, no. What it means is, give you an example, and I hate to, I don't want to keep this going any longer than we necessary, but say, for instance, someone was convicted of DUI and driving under suspended license. Let's say that happened. Well, the sentencing probably was primarily around the DUI.
We would think so.
Right. And maybe they were put on probation. And let's say they put on probation, and then the probation officer is doing whatever, and then they have to come back to court based on the probation report. Well, maybe they violated probation, so they go to jail for violating probation. Well, that person will be in jail for violating probation, but maybe they're on probation because of one of these things. So that would be somebody who the judges would say, maybe we need to release them, even though they're not in jail for violating this, they're in jail for violating probation. But the reason they're on probation is because of one of these. So out of caution, right, you just say, well, okay, we'll let you go for now as we review what's going on. But no, that doesn't put a dangerous driver on the street. It doesn't do anything. These are people who basically have tickets.
And the mayor's right. The 5 we let out today, the mayor was correct. The 5 people we let out of jail today, we didn't know all the circumstances, but we wanted to err on the side of caution. And I didn't know if they had any other charges or not that they were in jail for. So we set another court date. So we'll get a probation report. They're going to come back. We'll have to address every one of these issues. I'm not sure if it's going to be 500 or over 1,000.
Or it could be 20. It could be anything.
Yeah, so I'm not sure what the number is at this point in time. But bad drivers, and I also imagine that the only people who were in jail for driving without a license probably had more than 20 convictions. They just didn't want to get a license. So when you get that many, you go to jail.
Or maybe they had some fees and fines that the state prohibited them from getting the license because they owed so many parking tickets.
And they kept driving.
And they kept driving.
So this
So you better check yours.
So it's complicated, but we will deal with this issue and make it right. That's what we're here to tell you.
Okay?
Mayor, is the person that found this mistake here?
We're looking for that person so we can hire them.
No, well, no, they're not
Defense
here.
attorney.
They're not. It was a defense attorney. You know, they did good lawyer work.
Yeah,
They
yeah,
did
they
good lawyer
did. 10 months to discover it, so a lot of other people
Right.
didn't catch it. So, but we're glad it was found. We truly are. and we're
Yes.
going to take the corrective actions.
Is the people affected today, the release, is there a list of those people being there?
No, that's something we're not, I don't know if we should go into that because, you know, people, privacy is what it is. And I know it's not like a health record, but, you know, it's still. Well, then file, if you think you have a legitimate claim, file for freedom of information, and then they'll go from there. But we're just not going to give you a bunch of names. We're not going to do that.
I'm sorry.
All right, thank you very much.